Good morning. Just 2 days ago, the United States Justice Department announced that Bumblebee Tuna had agreed to plead guilty to a price-fixing conspiracy involving the canned and foiled tuna markets in the United States. They conspired with their competitors to inflate the prices of albacore and yellowfin tuna, and they agreed to pay a $25 million fine because they couldn't afford to pay any more. This demonstrates that antitrust enforcement in the United States is alive and well, both in the civil and the criminal arenas. But I'm a realist. Just the mere mention of the word antitrust is enough to make one's eyes glaze over. I mean, I just said the word antitrust, and I look over at Jerry Glass, and he's already beginning to do that. Once we start to talk about cross-elasticities of demand and market substitutes, it's enough to put somebody to sleep. Already, Felice down there is looking catatonic. but this is truly important because we represent the businesses, large and small, of America. This is very relevant to them. And we all have received that telephone call from the client who has, for the lack of a better word, that oh shit moment when they say, I've received this grand jury subpoena, or I've received this thing that says United States Department of Justice civil investigative demand. What does this mean for my company? And what should I do? So today we're going to talk about the practical aspects of antitrust investigations by the Justice Department on both the civil and the criminal sides. So have a cup of coffee. Have a cup of coffee, a piece of cake, sit back, and let's talk about antitrust law. I'm going to begin by talking about an overview of the Antitrust Act, and today's slide presentation is brought to you by the Hughes family knuckleheads. I figured that I could avoid a DMCA takedown notice if I use my own kids in this. The Sherman Antitrust Act is essentially two statutes. They've been around for 100 years. And the first one, the Sherman Act, Section 1, is 2 sentences long. It talks about conspiracies and agreements and the restraint of trade. Now, one thing that is really interesting is that it's framed in terms of the criminal aspect. It doesn't talk about the civil aspect. It says conspiracies and agreements and restraint of trade are hereby illegal, and they're declared to be a felony. But in the 100 years of the evolution of antitrust case law has carved out a specific area which is devoted towards criminal enforcement, and the larger portion is devoted towards civil enforcement. The touchstone in both civil and criminal cases is a conspiracy, collusion, or coordination among competitors or along a vertical distribution chain, meaning manufacturers, distributors, and resellers. And these are agreements that affect or impact interstate or foreign commerce. There are 2 types of cases. I'm going to take them out of order for a particular reason. The first type of case is the civil type of case. And this is called the rule of reason analysis. What are we talking about here? We're talking about trade association activity. We're talking about certain types of group boycotts, exclusive dealing arrangements, resale price maintenance in the vertical distribution chain, certain tying and bundling arrangements. And the focus on these types of cases in the rule of reason analysis, it examines the reasonableness of the restraint or the agreement. All right, and the examination goes into, ready for this, the relevant product market. Wake up, police. It talks about substitutes and what is called the cross-elasticity of demand, meaning if there's a small but significant price increase in one product, will that cause consumers to switch to another product? There is an examination of the relevant product market, which means is this a local, a regional, or national, or even international impact? And ultimately, for the Antitrust Division and for courts, the examination is weighing the pro-competitive aspects against the anti-competitive aspects to determine whether or not there is a violation of Section 1. Compare that to the a per se analysis. Now, the per se analysis simply says practices that have no competitive redeeming value are considered illegal per se, without any examination for their excuse or impact upon competition. What does that mean? The conduct is enough. So there's no examination into relevant product market. There's no examination into relevant geographic market. If the conduct occurs, that in and of itself is per se illegal. And that's where the sizzle comes in for antitrust law. What kind of conduct are we talking about? Blatant conduct. Things such as price fixing, bid rigging, certain group boycotts, market allocation. When competitors get together to conspire or agree on price or output, that's when the per se analysis is implicated. This is Bumblebee Tuna. It's also the subject of a Hollywood movie. Who makes a movie about an antitrust case called The Informant? Matt Damon on antitrust law. The second statute deals with monopolization. Again, just like Section 1, it's phrased in terms of criminal conduct. Monopolization or attempts to monopolize are hereby declared illegal and indeed a felony. Well, you can take solace. The last time the Antitrust Division actually prosecuted criminally a Section 2 monopolization case was in 1974. So almost universally, these types of cases are treated civilly. And the touchstone in the key to Section 2 cases is the intent to monopolize. What am I talking about there? Well, there's a tension. The goal in any free market economy is to win. In terms of Highlander, the movie, there can be only one. And when somebody wins in the game of the free market, we're all of a sudden going to penalize them by slapping them with a Section 2 case? Not exactly. The intent there is to use that monopoly power to prevent competitors to come in, the unlawful use of monopoly power. And when we think about that, we think of Microsoft and the Microsoft investigation of using their monopoly over the operating system to gain a competitive advantage in applications such as, for instance, the web browser. How many people here still use Netscape? Anybody? Anybody? Again, just like in the Section 1 rule of reason cases, the examination is into the relevant product market and market substitutes, and yes, Felice, cross-elasticities of demand. But the principal tools that are used by the Antitrust Division are the grand jury subpoena and the civil investigative demand pursuant to the Antitrust Civil Procedure Act. Search warrants in criminal cases can be used, but they're very, very rare. So let's talk about each. The grand jury subpoena is only involved in criminal cases and only involving cases with horizontal competitors. Generally speaking, they don't do the vertical distribution chain. They don't prosecute vertical distribution chain cases. These grand jury subpoenas come from main justice or one of the field offices. The various field offices, there's one here in New York, only deal in criminal cases involving horizontal competitors. What's interesting is that the U.S. Attorney's offices are never or very rarely involved in Sherman Act cases. Everything comes from main justice or one of their field offices. The Antitrust Division jealously guards their jurisdiction, and indeed in the U.S. Attorney's Manual, there is a provision in there that says that all Sherman Act cases have to go through the Antitrust Division. Like other grand jury subpoenas, they're generally served by an FBI agent. It seeks all sorts of documents and data related to the investigation, but unlike other criminal investigations, the FBI case agent does not run the investigation. It's all run out of main justice or the field division. The principal trial attorney is the one who is the principal point of contact, and quite often the case agent is left in the dark as to the status of the investigation. These grand jury subpoenas are voluminous. They seek nearly all the documents and data related to the investigation, but they are more focused than the CIDs because there is rarely a relevant product market or a substitutes examination. For the practitioner and for the in-house counsel, immediately you want to negotiate compliance, the timing and the scope. But through that, you get very valuable information to determine who the targets and the subjects are of the investigation. You use the negotiation for the key word searches to determine who is being investigated and why they're being investigated. And you establish your privilege issues to find out how deeply the corporation may be involved. The DOJ, again, expects to negotiate. So it's important for the practitioner and for the corporation to build their team from day one. Your e-discovery vendor to scour all the relevant data is important. But equally as important is the selection of co-counsel and joint defense for the corporation and for the individuals. Oftentimes, corporations will bristle at the idea of having to pay for counsel for their employees, whether they're targets or even the witnesses. But I suggest to you it is more economical and it's better to have all the elephants inside the tent pissing out than outside the tent pissing in. You can get a handle on where the investigation is going, what information is being provided to the Justice Department. You're going to want to hire investigators to conduct witness interviews, and oftentimes hire an economist. Why would you want to hire an economist if relevant product market is not relevant? The reason being is that if you bring in an economist, sometimes, in some cases, they can help you persuade the Justice Department to turn a per se investigation, criminal, into a rule of reason case, which is civil. And that can be a very valuable tool. You'll also want to consider bringing on public relations for crisis management. Budgeting, resources, and strategy. You want to develop a flexible strategy immediately. That will help you in the long run. And use those budget constraints to your advantage in negotiating subpoena compliance. I'm sorry, Mr. Trial Attorney, we can't do that. We don't have the money to do the breadth of the production that you want, or we just don't have the resources to do it in the time frame. They'll listen to that. Use the nature of the Antitrust Division to your advantage. The Antitrust Division is a highly bureaucratized agency. I often said when I was in the Antitrust Division that I'm not a lawyer, I'm a mid-level bureaucrat. There are layers upon layers upon layers of supervisors and chiefs and assistant chiefs. And all along the way, everything has to be approved. The trial attorney at the lowest on the line is micromanaged to the nth degree. So oftentimes, you're going, and you will have the opportunity to go up the chain several times to speak to those supervisors, negotiate compliance, and even negotiate, even to make your case why the company should not be indicted or should be given a deferred prosecution agreement. You'll also want to open up a dialogue for non-litigated resolution. Sometimes, if you settle early, it might be beneficial to the client. Archer Daniels Midland, in the mid-1990s, which is the subject of that movie, The Informant, settled for what at the time was the largest criminal fine ever, $100 million. The day after that plea was announced, Archer Daniels Midland stock shot through the roof. In the long term, it was a benefit to the corporation. Switching over to the civil investigative demand, that is the primary tool on the civil side for Sections 1, 2, and merger civil cases. This is basically a civil subpoena to assist the Antitrust Division to determine whether or not they should file a case. They are generally issued from main justice in the various sections that they have there. These are very voluminous. They seek nearly everything, and I liken those subpoenas or those CIDs to backing up a tractor trailer and emptying everything into it for delivery to the DOJ. And so you want to negotiate compliance and time it, generally a rolling compliance. Through that negotiation, you can determine whether it's a Section 1 or a Section 2 case, horizontal or vertical, and whether or not it's per se or rule of reason. Is the company a witness or a focus of the investigation? Just like the civil case, you're going to want to build your team from day one, the e-discovery vendor. But in these types of cases, your most valuable player is always going to be your economist. There is an entire section in the DOJ of economists, and they work hand in glove with the trial attorneys. They're the ones that the trial attorneys turn to determine whether or not a case should be filed. So bringing on an economist who can make the case why a case shouldn't be brought is very, very valuable. You'll also want to consider bringing on class action defense counsel, both in civil cases and in criminal cases. The enterprising plaintiffs bar are always on the lookout for the next class action case to begin. Most definitely in criminal cases, and quite oftentimes in civil cases, the class action cases follow DOJ action. So bringing on a class action defense counsel early on is often a wise move. And you also want to consider public relations crisis management. Budgeting, resources, and strategy, you got to manage the client's expectations. There's no way around it. The Antitrust Division investigations are long and they're very, very expensive. But use that time to your advantage and use the nature of the Antitrust Division to your advantage. Again, it's a highly bureaucratized institution. And so bringing in your economist to play upon the DOJ economist is very valuable. Oftentimes I'll write a white paper of 150 or 200 pages for the trial lawyers to let them chew on that, and oftentimes they won't come back because they're just scratching their heads. Again, attack the economic theory. Lastly, you got to make sure that your clients take this seriously. There's no faster way of turning a civil investigation into a criminal investigation than if the client doesn't take it seriously. Moody's in the mid-1980s, I sent them a CID. They gathered the information. They promptly shredded it. Ultimately, they pled guilty to obstruction of justice. On the criminal side, you don't want to be in a position at trial of having to produce for the first time documents that you should have produced previously. In conclusion, you want to organize and strategize from day one, build your team, manage your client's expectations, and use the Antitrust Division to your advantage. And through that, you can maximize your chances for success. Thank you very much.